Thank you. I
No
will
problem.
start over. And welcome everyone. Thanks so much for coming. If you haven't done so already, please mute yourself upon entry to eliminate any background noise. I am Whitney Richardson, the Illinois Power Agency's Legislative Affairs Manager. We're so glad to have you join us again today for the second session in the new IPA Summer School Series, an educational webinar series for legislators, government leaders, and staff to learn more about programs and initiatives pertinent to your work as legislators and point persons for constituents across the state. We designed this series to, first, bridge a gap in understanding of the IPA's work and its relevance to your constituencies and roles. 2, help you develop your knowledge of existing state solar incentive programs and consumer protections so you can communicate about these with your constituencies and navigate related casework with increased ease. 3, tell you more about our efforts to achieve statutory clean energy and equity goals. And 4, provide a forum for you to ask us questions and let us know what you're interested in. This year's IPA Summer School is a 4-part series. Last month, we discussed the 2 solar incentive programs administered by the IPA, and the recording and the slides for that session are now posted to the series registration page under the previous sessions heading if you scroll down to the bottom of the page. Today, we'll do a deeper dive into the consumer protections built into both solar incentive programs. In September, session 3 will cover the equity initiatives that make up part of our work in the clean energy transition. In session 4, we'll discuss progress towards statutory clean energy goals. After each session, we will share some collateral with you, as well as a recording of the presentation to support your learning and communications regarding these topics. Today's session is an educational forum, and the presentation portion will be recorded for future use. The presentation does not represent a legal interpretation. It will focus on the IPA consumer protection initiatives associated with the 2 solar incentive programs we discussed last month, Illinois Shines and Illinois Solar for All. We'll reserve a few minutes at the end of today's session to respond to any general questions related to today's topic. The question and answer portion of the session will not be recorded. I will now turn the floor over to the IPA's director, Brian Granahan, to give a brief introduction to the Illinois Power Agency and its consumer protection obligations.
Great, thanks, Whitney. Here's, of course, the schedule for the upcoming sessions. This one is on consumer protection work in the IPA solar incentive programs. Our last one was about understanding the IPA solar incentive programs. And so hopefully these two link together well. So we go to the next slide. So a brief overview about the IPA. I think many of you are familiar with the IPA. You probably heard some of this in the previous presentation. We're responsible for implementation of the state's renewable portfolio standard, which requires that Illinois electric utilities achieve a certain percentage of their retail sales through clean energy through the procurement of renewable energy credits. We implement the Illinois Shines program and the Illinois Solar for All program. Those were covered in the last webinar. And as part of the administration of those programs, we've created different consumer protection requirements. And this actually goes back to the launch of those programs back in 2019, and even further back than that. After FEJA's enactment in 2017, the IPA was tasked with standing up these new solar incentive programs that would provide opportunities for rooftop solar and community solar for Illinois residents. And how we did that was wrapped up in what's called our first long-term renewable resource procurement plan. And in that plan, we proposed having consumer protection requirements that were equivalent to what, say, the Illinois Commerce Commission had for retail suppliers at the time. And that was something that was approved by the ICC in 2018 and then folded into our programs that launched in early 2019. As Rachel will get into in a little bit, a lot of this was codified through the Climate and Equitable Jobs Act back in September of 2021, and we brought Rachel Granahan on board as our Consumer Protection Counsel in January of 2022, and you'll be hearing a lot from her today. So this has been a big part of the IPA's work, but one of the places where we're quite a bit different than, say, the Illinois Commerce Commission is that we are not a regulatory agency. We implement these different solar incentive programs, but our ability to enforce consumer protection requirements ties back to those purse strings, ties back to the availability of incentives, and it isn't the ability to issue fines or revoke business licenses or to take steps like enforcing criminal fraud statutes. So that is how we approach consumer protection, and across the slides to come, Rachel, who Whitney will introduce next, will provide a great overview of how the IPA approaches its consumer protection work.
Thank you, Brian. Next slide, please. Great. I will now introduce you to our main speaker for today's program. Rachel Granahan is the IPA's Deputy Legal Counsel, Consumer Protection. Rachel joined the agency in January of 2022 to head the newly formed Consumer Protection Division of the Legal Bureau. She works closely with our program administrators, Energy Solutions for Illinois Shines, and Elevate for Illinois Solar for All on handling complaints and program violations, and she leads the development of new consumer protection initiatives. Her team currently includes Karen Craig, Consumer Protection Specialist, and the team will be growing in September with the addition of an Associate Legal Counsel. I will now turn the floor over to Rachel to begin today's presentation.
Thanks so much, Whitney. Good afternoon, everyone. Very excited to talk about consumer protection with you today. So a brief overview, we're going to start with sort of high-level commitment to consumer protection and our statutory authority. And then we're going to go through three subparts. First, we're going to talk about our program requirements. Secondly, we'll talk about education resources and how we get stakeholder input in developing our programs. And part three, we'll be talking about some specific consumer protection issues that we often see arise and what we're going to do to proactively address them. And then finally, we have a Q&A session at the end. So what do we mean when we talk about consumer protection? So first of all, of course, everyone thinks about protecting consumers against misleading and unfair business practices. And this is a really, of course, key part of our consumer protection work. We also think that education is a very important part of consumer protection because it helps residents and businesses make informed decisions and really understand what they're doing and what their options are when they decide to go solar. Consumer protection requirements also make sure that customers have a positive experience when they participate in our programs. And this in turn builds trust in our programs and in going solar more generally. And then finally, of course, as a state program, we want to make sure that the state administered incentive funding only goes to support those companies that are responsibly serving the public. So turning to the statutory language, because I'm sure all the legislators and legislative staff are interested in sort of what's our legal authority here. So as Brian mentioned, the Climate and Equitable Jobs Act passed in the fall of 2021 really codified a lot of consumer protection requirements that we were already doing, but puts them in law and makes it clear exactly what the agency is expected to do with respect to consumer protection. So this is in the Illinois Power Agency Act, Section 175C1M, and it directs the agency to establish a registration process for companies that participate in our programs and maintain a list of those companies. And here, I bolded this because this is important, we can revoke a vendor's ability to participate if they fail to comply with requirements. So again, this goes back to what Brian was saying, which is the agency doesn't issue business licenses, and we don't revoke business licenses. What we can do is tell a company that they can no longer participate in our incentive program and they can no longer access that incentive funding. But we could revoke a company's ability to participate in our program. We could suspend them from Illinois Shines or Illinois Solar for All, and that would not actually impact their ability to build solar projects or sell solar projects outside of our program if they did not have anything to do with their program and did not apply for our incentive funding. So that's sort of an important piece to understand in terms of the scope of our authority and how we run the program. Secondly, we are directed to establish program requirements and minimum contract terms that have to be included in all the contracts between the customers and the companies. We are given the authority to require standardized disclosure forms, which we will also talk about in a minute. We are directed to establish consumer complaint centers so that we can accept complaints, help address them, and also publish a list or report of the complaints that we receive. We are also directed to file an annual report on complaints and any action we take in terms of discipline, and we file that annually with the Illinois Commerce Commission. We are also directed to have regular meetings with the Office of the Attorney General, the Illinois Commerce Commission, and any other stakeholders who are interested who want to talk about consumer protection issues with us. And then finally, we are also directed to, as appropriate, refer complaints to other legal authorities if it falls within their jurisdiction or other law enforcement agencies. And as I explained, the way that these consumer protection requirements are set out in the law, it reflects and articulates the scope of our authority. So we can do disciplinary action up to revoking the company's ability to participate in our program. And as I said, this codifies a lot of existing practices and requirements, but it just clarifies and puts it in law that we need to be doing this and gives us that authority in law. So part one, we're going to talk about program requirements, starting with registration. our consumer protection handbook, our contract requirements. We'll talk about our disclosure forms, and then we'll talk a little bit about complaints and what we do when a company does not follow our program requirements. So the first step for any company that wants to participate in our program is they have to register with us. So the first slide here is about approved vendors. So approved vendors are sort of like the key actor in our program, and they are responsible for submitting project applications to both Illinois Shines and Illinois Solar for All. And they are the entity that actually takes the renewable energy credits, and those are sort of intangible certificates that represent the renewable nature of electricity that's generated from a renewable energy source. So when a solar project is generating electricity, every time it generates 1 megawatt of electricity, it generates 1 renewable energy credit, and that REC can be sold independent from that underlying electricity. And that's how we track compliance with the state's renewable portfolio standard. So the approved vendors track the RECs that are generated from the solar projects and sell those to the local utility, either Ameren or ComEd, in exchange for an incentive payment. And then the approved vendors, so they do the RECs to the utility, they receive the incentive payment, and they're also responsible for supervising any subcontractors that they bring in to help work on projects. So approved vendors have to apply to the program. They have to fill out actually a fairly detailed application. It asks about, have they had lawsuits previously dealing with consumer protection issues? Have any of their owners gone bankrupt recently? It asks about the ownership structure, all sorts of detailed information so that we can really review and vet whether or not this is a company that's appropriately going to be participating in our program. And we can either approve the company, conditionally approve them, or deny their application. When an approved vendor applies to participate, they have to agree. They sign an attestation that they will comply with all program requirements. They have to renew that application annually. And again, registration is not a licensing process. It's not a business license. It's just their registration to participate in our program and be eligible to receive incentive payments through Illinois Shines or Illinois Solar for All. And then our second category of companies that participate in our program are called designees. So these are entities that work on behalf of an approved vendor, and they interact with end-use customers. So these designees are subcontractors that can do marketing, advertising, they can do the actual sales and the contract signing, they can do the installation, etc. So the designees also have to register with the program. They also have to comply, they have to agree to comply with program requirements, and they also have to renew the registration each year. And as we saw in the statutory requirements, we are directed to publish a list of our approved vendors and designees. So we have the links here if you're interested in taking a look. The lists of the approved vendors and designees for each of the programs are published on our website. All right, the next thing I want to talk about is the Consumer Protection Handbook. And this is sort of our key consumer protection document. And it lays out all of the marketing, the sales, the training, conduct, and other requirements for approved vendors and designees that participate, and it applies to both of our solar incentive programs. So some sample general requirements: approved vendors and designees have to give accurate information to prospective customers about how much the project will cost and how much the project will save them. They can't make any demonstrably false or unsubstantiated claims about savings to customers, and they shall not describe the program as providing a tax credit. We often hear customers confused. They think that our program is a tax credit or a rebate. It's really not either of those, and so we discourage companies from describing them as such. In the next slide, we have a couple more sample requirements, and this just shows you sort of the scope and breadth of the type of stuff that's covered in our Consumer Protection Handbook. So sales agents that do in-person solicitation, like door-to-door marketing, for small solar projects, like residential size projects, they have to wear an ID badge. That ID badge has to have their name, their photo, their company, and an ID number. If a in-person solicitor comes across somebody who doesn't speak English, they either have to be able to speak in that customer's preferred language, they have to get a translator, or they just have to stop that solicitation to make sure that people who don't speak English as their first language are not taken advantage of. All customers must receive and sign a standardized disclosure form before they sign a contract, and we'll talk about this one a bit in a couple slides. Another just sample example of a requirement for community solar is if a community solar bill is going to be delayed, which we do see happen because of utility billing issues. If the community solar provider is going to bill the customer for 3 or more months at once, they have to offer a payment plan so that the customer isn't hit with this large bill at once that they weren't expecting. And that's shortened to 2 months for Illinois Solar for All because we're dealing with low-income customers there. We also have contract requirements. So these are the terms and the information that needs to be included in the contract that the customer signs with the solar provider. So for distributed generation, which is on-site solar, like rooftop solar, those contracts have to include all costs and fees, information about how the project is being designed, warranty information, what procedures would be used in the case of a dispute, and what governing law applies. And then we have special requirements for Illinois Solar for All because of the vulnerable population that it is intended to serve. So for example, any contracts that have an ongoing payment have to include forbearance provisions. They also get extended rescission periods. So for on-site solar, like rooftop solar, Illinois Solar for All customers get 14 days after they sign the contract where they can rescind and say, I don't want to move forward with this after all. They have 14 days to do that and cancel the contract without any penalties. And then a couple more specific requirements for ILSFA, for Solar for All. Participants should see no upfront costs. There are a couple minor exceptions to this, but for the most part, residential customers will not have any upfront costs through the Solar for All program. And one of our key provisions for Solar for All is a minimum specified savings requirement. So participants, their ongoing costs can be no more than 50% of the value of the electricity generated from their project or their subscription if it's community solar. So basically their costs can't be more than 50% of the value that they receive from going solar. Okay, I've talked about disclosure forms several times. We finally got here. So prior to signing a contract, the approved vendor designee has to give every customer a filled out completed disclosure form. And that customer must review and sign the disclosure form before they sign a contract. And the forms are designed to provide clear and consistent information that highlights the most important information about that solar project and about that transaction. And the key is that the customer has to review it and sign it before the contract so that we are confident that the customer received that information and was able to review it before they enter into a legally binding contract. So for example, some of the information included in a DG disclosure form, which again, that's distributed generation or on-site like rooftop solar, includes costs and fees, the size of the project, the amount of the Illinois Shines or Illinois Solar for All incentive that the approved vendor will receive for that project, information about the installation, warranties, and also the financial benefits of that project. So we've got links at the bottom, and then our next slide is some screenshots of what the disclosure forms actually look like. So this first page here is an Illinois Shines disclosure form for a project that is being purchased as opposed to being leased or being financed through a power purchase agreement. So you can see the first, it's a little bit small here, but the first section, the first page is mostly contact information. The second page includes information about costs. That green box, or about a third of the way down on that second page, is highlighting the total amount of costs and fees for the project. So that's really called out and highlighted for the customer. That diagram or graphic on the third page helps the customer understand the expected performance of their system as compared to other solar projects that participate in the program. So if they have maybe a roof that doesn't face the right way or is shaded and somebody is proposing to them a solar project, they can see with this diagram, you know, if there's an issue and maybe it's not the best design system, they'll be able to have that flagged for them in the disclosure form. Then the fourth page shows savings estimates, and it also has that important signature spot at the bottom so we can make sure the customer actually received and reviewed the information. And then our next slide is basically the same thing or a similar thing for Illinois Solar for All. The disclosure forms look and feel very similar, but they're done with the Illinois Solar for All colors and fonts. So contact information, this one is actually for a community solar subscription rather than on-site solar. So contact information, costs and fees, information about early termination of the subscription, And then again, the last page provides estimates of the value of the electricity and the overall savings percentage. So this is how we confirm that the estimates show that the costs to the customer will be no more than 50%. And that percentage is calculated in the disclosure form and placed on this fourth page so the customer can see what their savings percentage is. Complaints and program violations. So sometimes we do have things that don't go perfectly well. We do sometimes have bad actors in our programs. So if a customer does have a bad experience or needs assistance in some way, they can reach out to our program administrators through the customer complaint center, and our program staff will reach out to the customer, get as much information as they need, and then they will reach out to the company and try to mediate a resolution. If we do see companies that are consistently not complying with our program requirements, then we can take action against them as we talked about earlier with respect to the statutory authority. So our process will always start with a notice of potential violation, and that just lets the company know what we think they might have done wrong and cites the specific provision that we think they might have violated and gives them an opportunity to give their side of the story and explain if they think they didn't violate it, what the basis is for that. But if we do confirm that a violation has occurred, we can require a company to take corrective action. We can require a company to follow a compliance plan. For more egregious or repeated violations, we can send a warning letter. And then for the most serious issues, we can actually suspend that company from participating in the program. And again, that's not a revocation of a business license. It's not a prohibition on operating in the state generally. It's just saying that that company can no longer participate in our program and benefit from the incentive funding that we provide. Part two, so this is about education and reports that we have on our website, and then a little bit about our stakeholder groups. So education, as we mentioned, that's one of our sort of fundamental elements of consumer protection and how we think about consumer protection here at the agency. So the websites are a really key source of information. You have probably noticed throughout this presentation so far, there have been a whole lot of hyperlinks. Those all go to the Illinois Shines and the Illinois Solar for All websites because we have all of these resources there so that they're public and accessible. We have program brochures. These inform consumers of their rights, procedures for filing complaints, and other information related to the incentive programs. These brochures are actually now automatically attached to the disclosure form to make sure that customers receive them, and they are available in both English and Spanish. And then we have them for the different types of projects and offers. So we have for Illinois Shines, we have them for distributed generation, which is again on-site, for community solar, for our public schools, and then for Solar for All, we have them for the various categories for Solar for All as well. We also have our disclosure form deep dives, and these are a resource that helps customers understand their disclosure form, and it gets into some of the more nitty-gritty information that doesn't necessarily fit on the disclosure form itself, but if a customer wants that next level of detail and understanding of things like net metering policy, they can go to these deep dives, which are an online resource, and they basically, if I were to sit down with somebody and walk them through their deep dive or walk them through the disclosure form and explain which each section meant and what they should be looking at, that's what the deep dive does, is it walks you through your disclosure form and helps you understand what each section is talking about and gives additional background information and details. So even some more resources. So for Illinois Shines, we have a project lookup tool. So if a customer wants to know the status of the project application in Illinois Shines, they can check that. It will tell them what the status is. And an accompanying resource is the Guide to Going Solar, and this lays out the steps and the timeline for the Illinois Shines application process. So if you're using the lookup tool, you can see what step it's at. You can look at the Guide to Going Solar and see where that step is in the overall application process. A specific resource for Illinois Solar for All is our grassroots educators. So grassroots educators are trusted members of the community, and they engage income eligible residents and educate them about the Illinois Solar for All program. And each year of the program, a new group of grassroots educators is selected and funded to help spread the word about Illinois Solar for All. And then this final link here is actually to the agency website itself, which has a bunch of fact sheets, including about both of our incentive programs and about consumer protection generally. All right, and then these are some more reports that are available on our website. So the first one is our violations report. So anytime a company is ever suspended from our program, their name will be on this violation report. So if a customer wants to do some research on companies, they can look and see, was this company ever suspended? Even if that company has since re-entered the program, they will still be listed on this violations report. We also list recent warnings. So any company that has received a warning letter in the past 12 months will be identified in a brief summary of why they were sent a warning or why the company was suspended. That summary will also be available in the report. We also have complaints reports, and this actually lists out every single consumer complaint we've ever received in both programs. So lots of transparency and visibility into the programs. And again, this is a resource that customers can particularly take advantage of when they are looking to select a solar company. They can go and see what sorts of complaints there have been, if there were any recently, and what the topic of the complaint was. And we have a complaint report for both Illinois Shines and Illinois Solar for All. And then finally, we have our annual complaints report, which is filed with the Illinois Commerce Commission, and that contains information on complaints from both programs and also summarizes any disciplinary action taken in that past year. We also have a consumer protection working group, and this is a really important way for us to get feedback and sort of directly interact with stakeholders and talk about consumer protection issues and solutions. So we meet virtually on the first Friday of the month. We've had 22 meetings since we've launched this group in October of 2022, and it engages a diverse set of stakeholders so that we can have a really robust conversation. For example, a lot of the participants are approved vendors and designees in our programs. We also have trade groups participate. Illinois Commerce Commission staff attends. The Citizens Utility Board often attends. Grassroots educators attend. And sometimes we do even have just individual consumers who will attend this working group. So like I said, it helps to provide direct insight and perspectives to our program administrators. And the working group is also attended by agency staff, including myself and Karen. And feedback that we get from this group helps inform how we develop our strategies and decisions on various consumer protection issues. So for example, one thing that we've talked about a number of times in the working group is an issue of stranded customers. And we're going to talk about this in a couple of slides. But it's essentially when companies go out of business, they'll often leave behind customers who sort of end up being stranded. And we heard a lot from companies about why this was a problem and why it is difficult for companies to help those customers because their situations are often very, very unusual or very specific, so that standard approaches don't always work. Sometimes there's issues with the systems. There's additional risk to take on those projects. And so taking that feedback into account, we came up with an idea of developing an extra economic incentive for companies who help these stranded customers. So we'll talk about that. That's called our Stranded Customer Rec Adder, and that's in just another couple of pages. And then one more note is that we also do hold regular meetings just with the agency, the program administrators, the Attorney General's office, and Illinois Commerce Commission staff. So that's where we can have conversations about like specific companies that wouldn't be appropriate necessarily for a public forum. And we can refer specific complaints or issues with companies to the Attorney General's office. And so I just brought back this slide here, and I want to run through it and show you that we've gone through all of the items on here. So we've talked about the registration process for approved vendors and designees. We have that list published on our website. We have developed our consumer protection handbook and our minimum contract requirements. We do have standardized disclosure forms, which are required to be provided to all customers before they sign a contract. We do have our customer complaint centers, and we have dedicated staff to accept those complaints. And we publish a report on all the complaints that we receive. We also do file an annual report with the Illinois Commerce Commission that summarizes complaints and enforcement actions. We have our regularly scheduled meetings with stakeholders and with the Attorney General's office and the Illinois Commerce Commission. And finally, we do also refer complaints to other legal authorities, such as the AG's office. And that brings us to our last part, which is talking just a little bit about some specific consumer protection issues that we've seen recently in our program. our programs and what we're doing to address them. So as I mentioned, stranded customers. So when we say stranded customers, we're talking about a customer that's already signed a contract with a solar company, and then either the approved vendor or the approved vendor and the designee, or just the designee, goes out of business, or sometimes could be suspended from the program and can no longer proceed with the project. So the customer wants a solar project, signed a contract for a solar project, but now something's happened and they don't really have a path forward to either get that solar project completed, or they don't have a path forward to actually have that project participate in our incentive program. So what we've developed so far are our consumer protection stranded customer resource page. And processes. So the program administrator in Illinois Shines, when a company goes out of business, will reach out to their customers and give them resources and what information we have about their possible paths forward. We've developed what we call our short list of companies, and these are companies that are interested and willing to take on stranded customers, and they've also met heightened eligibility requirements. So we don't let people on the short list if they've had recent problems or violations in our program, because we want these companies that are helping stranded customers to meet a higher standard to make sure that these customers who've already had a problem can now be working with a company that's definitely not going to cause further problems. And as I mentioned, we're also working on developing this REC adder, which is the first of the 3 items here. So these 3 incentives listed here were all approved as part of our last long-term renewable resources procurement plan, which is approved by the Illinois Commerce Commission in a docketed proceeding. So the REC adder is the way the incentive works is that there is a price per REC. So that renewable energy credit that we talked about that the approved vendor sells to the utility, there's a set price per renewable energy credit. And we are going to be developing an adder or an increased bonus on that, which will apply when an approved vendor rescues a stranded customer. So we've heard, as I said, from approved vendors and designees that there's extra cost and risk involved in supporting these stranded customers. And so we're going to be offering this added economic incentive to help cover that extra risk and cost and make sure that there are companies who are willing and able to help support these stranded customers. Secondly is our escrow process. If we could just go back 1 slide. So in the Illinois Shines program, one of the models we often see is that the approved vendor looks and sees, well, once they apply the project to the program, they're going to get an economic payment, an economic incentive, the REC payment of a certain amount of money. And then they tell the customer up front, hey, we're going to be getting this money down the line and we will pass through X dollars to you. So the approved vendor might say, this project is going to receive an Illinois Shines incentive of $10,000. And so once we, the approved vendor, get that money, we will pass through 8,000 of it to you, the customer. And what we see sometimes is occasionally we'll have a bad actor who makes those promises and then does not actually pass through that payment to the customer. And so the escrow process would be used when we have significant concerns and we've seen a pattern of an approved vendor not passing through that payment as promised. And instead of the utility paying the money to the approved vendor and the approved vendor paying the money to the customer, we would insert a third-party entity, an escrow agent, into this process. So the utility would pay the money to the escrow agent, and then the escrow agent would make sure that the money does actually get to the customer as promised. And then our third new initiative that we're working on developing is our solar restitution program. And this is going to work to provide compensation to customers who have been harmed through their participation in Illinois Shines or Illinois Solar for All. They will have to go through our complaint process first and meet eligibility requirements, but we are not going to require that they go to court and get an actual legal judgment or order. There will be some caps on the maximum amount of money available. And this was laid out in our long-term plan again and approved by the Illinois Commerce Commission. So there will be a cap of $30,000 per individual solar project and $200,000 that can be paid out based on conduct of a single approved vendor or designee. So that's it for the substantive information here. If you would like to reach out to us or our program administrators, we've got contact information here if you've got questions, or if you have a constituent reach out to you who needs assistance with their solar project or with going solar, we've got all that contact information here.
Thank you so much, Rachel. I am now going to end the recorded portion of the presentation.